Without any delay, I will now cede the floor to our two speakers, and Professor Green will go first.
Okay, well, thanks again for everyone for, I don't know if we need this, but what the heck, for coming. It is a great fun to be able to be here discussing with my, I always describe Professor Siegel as my Twitter frenemy. So we are genuine friends. We've enjoyed 2 meals together in the last 18 hours or so, and some other meals at conferences in the past. But it is a great joy to be able to discuss these issues civilly. Not all discussion on Twitter, you may have found, is civil. We do try to be a little fiery, but perhaps this format will be work as well. So, what is originalism? Is it a good idea? The word originalism, there's lots of, I have more handouts when we have people here, by the way. But if you want a handout, you can have that. I posted this online on Saturday and immediately got some people on Twitter saying wacky things about it. But the word originalism really kind of entered modern life in 1980. So Paul Brest actually was using the term originalism to describe a position he opposed. Okay, so in 1980, what did he say? He said, by originalism, and he's coining the word. This is the first sentence of his famous article, The Misconceived Quest for Original Understanding. He says, by originalism, I mean the familiar approach to constitutional adjudication that accords binding authority to the text of the Constitution or the intentions of its adopters. Justice Scalia, in 1988, adopted the term as his own. I said, originalism, the lesser evil. And since 1988, it's been used a lot by proponents to describe their own positions. Now, Brest's idea of binding force, I think, is essential to get a hold on something to use the term for that's going to be an interesting thesis. Now, the thesis that I want to defend, the thing that I think is at least one way we can use the term originalism, is that the meaning originally expressed by the constitutional text is binding, even if it's a bad idea, or even if it doesn't go far enough. Okay, that's one way of being a bad idea. So how do I want to show that? Well, basically I've got, this is the big, exciting, dramatic moment. Okay. Now, 3 propositions that are going to prove this to you. Okay. The Constitution is binding. Okay. Eric last night said, I agree with that. Okay. So I'm 1 for 3. 1 for 1. Okay. Second step, the Constitution we've got that's in force today is the original Constitution. Okay. Last night Eric said, well, I'm going to step on that. Okay, so we should get some clash on that issue. We're not to original meaning expressed by the text being binding yet, though. We have to get another thing. The original Constitution is the meaning originally expressed by the text. Okay, so step 1, okay. So I've got 10 questions, 10 propositions when you give answers to these. At some point, it'd be good. I think, everybody thinking about the Constitution probably ought to think about these 10 questions. Figure out what you think at some point in your life, maybe figure out what your answer is to these 10 questions. And Professor Siegel, of course, will talk about perhaps some other things in his 20 minutes. But at some point, I think it would be good to just ask, what are his answers to these? So the first 3 of these are going toward showing the Constitution is binding. Okay, it's not okay for the Supreme Court to make things up about the Constitution. Somebody on Twitter he disagreed with that first proposition, but I think it's pretty commonplace. It's not. I think it's not always wrong to make things up. So if somebody comes through the door and says, I want to kill Siegel or something, I want to kill Green, okay, and I duck behind this massive podium, it would be, I think, morally permissible for you to say, yeah, I do too. He went that way. Okay, make up a story. Okay, and then I run away. Lying to murderers at the door, standard ethical hypo. Okay, is the Constitution so bad that it would be okay to do that kind of thing? I don't think so, but you can perhaps disagree. Some people might disagree. Okay, is it the Supreme Court's job to fix the Constitution? No. Supreme Court has a job. It's to exercise judicial power. And I'll get out my one of my many pocket constitutions. Keel Amar said you have to have at least 2 in your pocket at any time so you can give one to your friends. So I've got 3. But in case I run across 2 friends at the same time. So Article 3, Section 2, Paragraph 1, Clause 1. This is, I think, the most important description of the Supreme Court's job in the Constitution. The judicial power shall extend to all cases in law and equity arising under this Constitution. Deciding a case arising under the Constitution is different from fixing the Constitution. If you're allowed to fix the Constitution at the same time you're deciding cases arising under it, you're really just deciding cases. You're not deciding cases arising under an externally existing Constitution. Okay. Third question, is the Constitution binding even if some of its provisions are bad ideas or don't go far enough? Well, Article 6 says this Constitution shall be binding. That's not exactly what it says, but this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. That's our first explanation that this Constitution is binding. Okay, there's another provision. The senators and representatives before mentioned, and the members of the several state legislatures and the all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation. So how is it binding? By oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. So adhering to the Constitution is a matter of keeping your promises. Some people today think promise keeping is no big deal. I'm not among them. I do not encourage you to be among them. Okay? If you were to say, I have got this great defense of some crazy new thing that the Supreme Court just did, the Supreme Court doesn't have to keep its promises to us when it decides constitutional cases. That is not, I don't think, going to sell very well. If Judge Kavanaugh, if he were trying to become Justice Kavanaugh, he said, well, here's my program for becoming a justice. I'm not going to keep the promise I make to you when I swear an oath to the Constitution. If the senators were going to say that, I dare say it would cause a stir, and rightly so. Okay. But we agree on this, I think. The Constitution is binding. The Constitution, whatever that is. The what is, the whatever that is. Okay. Next step. This is a distinction that I will be very tempted to put into philosophical jargon, but I'll try very hard not to. Okay. Can we fix applications of the Constitution without fixing the Constitution? So you've got the Constitution, that's one thing. What is it? It is a collection of principles. It's not a collection of particular results, but principles, okay? And you can keep the principles the same, but you can correct the application of those principles. Okay, how do we do that? Well, my first example is really simple. Article 1, Section 2, Clause 3. How is the House apportioned? It's apportioned according to population. Representatives and direct taxes, which may be representatives and direct taxes shall be apportioned among the several states, which may be included within this union, according to their respective numbers. So bigger states have more reps, smaller states have fewer reps. Okay. How did the framers expect this to be applied? We have very good evidence of this in the interim rules that are in this very provision. The number of representatives shall not exceed one for every 30,000. Every state shall have at least one representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantations 1, Connecticut 5, New Jersey 6, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. The framers thought that North Carolina was smaller than Maryland in population. They were wrong about that. Took the first census, turns out North Carolina is bigger than Maryland. Okay, so obviously, if we're going to apply the principle in Article 1, Section 2, Clause 3, you have to use the actual facts. You can't just use the framers' expectations. You can correct the framers' expected applications of their principles. Second example, this is going to be a little more controversial. Equal citizenship for women under the Privileges or Immunities Clause of the 14th Amendment. Equal civil rights, but not equal political rights. So in 1866, if you look at the public debate about the 14th Amendment, you'll find this exchange, I think at least 15 times on either side. So by far the most frequent thing said in 1866 about the 14th Amendment are this exchange. Democrats say over and over, hey, we shouldn't have a provision saying that it's unconstitutional for states to make or enforce laws which abridge the privileges or immunities of citizens of the United States. It would be bad to have that because that will make the freemen voters. Okay, so the freemen, they're emancipated by the 13th Amendment. They're made citizens by the 14th Amendment. They're made voters by the 15th Amendment. But Democrats thought, and they alleged, they said the reason not to vote for these Republican folks is because they want to give the vote to the freemen now under the 14th Amendment. So the Democrats said this over and over and over again. Republicans reply over and over and over again, over 15 times. What do they say? They say, that's not right. Our amendment, our 14th Amendment, only gives civil rights. The rights of citizens, that's in the text, rights of citizens, not political rights. And in fact, women are citizens of the United States. Children are citizens of the United States. That's in the citizenship definition of the 14th Amendment, but they're not voters, okay? How does that make sense? That only makes sense if the rights of women under the 14th Amendment, the civil rights of women, under the 14th Amendment are a useful guide to the civil rights of the freemen. If you go back and you say, oh, the women were completely excluded from the 14th Amendment, they're not excluded from the text. And when the 14th Amendment was discussed, women's rights, women's civil rights, were used as an example for showing what the civil rights of the freemen would be. It would not include voting. You only get voting for the freemen under the 15th Amendment. It doesn't get enforced very well until the 1960s, really. You only get voting for women under the 19th Amendment, political rights. But you get civil rights for women under the text of the 14th Amendment. Okay, what are civil rights? Civil rights are the rights to be treated the right way by the government. Political rights are the right to control the government. They're not included in the rights of citizens. But in 1868, notwithstanding this provision, most people, not all, most people thought that it was okay to exclude women from the practice of law. Why did they think that women had civil rights, had the rights of citizens of the United States, but it was okay to exclude women from the practice of law? Because they thought it was non-arbitrary to make that distinction. The rights of citizens of the United States are the rights to have the same privileges as similarly situated fellow citizens of the United States. But the distinction between men and women, a lot of people thought, was non-arbitrary when applied to exclusion from being a lawyer. Women's temperament, the argument went, women's temperament didn't suit women for practicing law. This was a factual assumption. Just like the factual assumption about Maryland having more people than North Carolina. Because it's a factual assumption, We can fix the application of that principle. And we can say, well, I agree with Senator Matthew Carpenter and Chief Justice Chase rather than everybody else in 1872 and 1873 on that question. We can disagree with the majority opinion about the facts, but we are not, when we do that, fixing the principle expressed in the 14th Amendment. We're not turning the 14th Amendment into the 19th Amendment or into the 15th Amendment. Okay. So that's explaining basically the distinction between a text and the application, which is going to be important, saying the meaning originally expressed by the text is what's going to be binding. That's what is the Constitution. Okay. What is the Constitution? It's not what the Supreme Court says. This is not Supreme Court Day. This is Constitution Day. How do we know this? If you're going to say that the Constitution is what the judges say it is, well, one of the things the judges say about the Constitution is that it is not the same as what the judges say. So you look at, so here's a sentence that you see a lot in Supreme Court opinions. Such and such earlier decision was wrong the day it was decided. So Casey says this about Plessy. Casey in 92 says this about Plessy in 1896. Trump versus Hawaii says this about Korematsu. Trump versus Hawaii from last spring about Korematsu in 1944. Lawrence versus Texas, 2003, says this about Bowers versus Hardwork in 1986. If something is wrong the day it was decided, it can't be wrong simply in virtue of the later Supreme Court decision. That didn't exist the day that those earlier decisions were decided. It's got to be in virtue of some external reality. Similarly, if you're going to say, hey, we should overrule cases like Adirond or Seminole Tribe or Prince from 95, 96, 97, you are going to want to say we should do that in virtue of something. What? It can't be in virtue of those cases. Those cases agree with themselves. It's got to be in virtue of the Constitution. Okay. Next move, this is sort of shutting a door that some people have been tempted to make. Can a new justice on the court understand the nature of the Constitution incorrectly? This is, I say yes. I guess I got 2 no answers, 5 yes answers, and 3 answers of the founding. Okay. This is essential for 2 justices to have a common constitution, common objective interpretation. So when the Supreme Court says something, they say the Constitution means something. If what Justice Thomas swore an oath to support in 1991 is different from what Justice Breyer swore an oath to support in 1994, that couldn't work. It's got to be external to the oath taker. Okay. Does America have the oldest operational constitution in the world? This is actually in the introduction to Eric's book, and I think it's true. I think it establishes this second proposition. The Constitution is the original Constitution. The Constitution, in effect today, is really old. Okay, if you Google how old is the Constitution, you're going to get an answer based on the founding. Okay, final bit. These last 3 things. Why is it the original meaning expressed by the Constitution? 3 examples. First, the word now. The word now is in the Constitution. If you ask the Constitution, what time is it? They'll say, well, it's now. What does that mean? Article 1, Section 9, Clause 1 says the importation or migration or importation of such persons as states now existing, think proper to admit, shall not be prohibited prior to 1808. And it's like, oh, that's a bad provision, protects the slave tribe. True, okay, it's a bad provision, but it's part of the Constitution. And it says now referring to the founding. It does not include Kentucky or Ohio in its protection for the slave trade. Second example, he. 18th century language norms said you can use, they're chauvinistic. You can use he to refer to all human beings. How do we know this? The fugitive, returning of fugitives clause in Article 4, Section 2, Clause 2 uses he to refer to fugitives. Female fugitives would be included. Sixth Amendment gives rights to female defendants with the word he. So women, of course, can be president, despite the fact that he is used in Article 2, if you use 18th century language norms. But you got to be careful if you take an 18th century text and you apply 21st century language norms, that's what makes it possible for women not to be president. So if you think it's super important for women to be president, you have got to use 18th century language norms. Final example, the time of the adoption of this Constitution. This is in Article 2, Section 1, Clause 5. And it says that if you are a citizen of the United States and at the time of the adoption of this Constitution, you can become president. Anytime anybody makes an argument about the Natural Born Citizenship Clause, they are assuming that we are not adopting the Constitution today. Ted Cruz is a citizen of the United States today, but he obviously doesn't partake of this because the time of the adoption of this Constitution is the founding, not today. So, under 20 minutes. Thank you.
I'm always the high energy person in the room. I'm not sure what to do with this. First of all, thank you all for having me. I'm so flattered to be here. Thank you to, I'm going to call Chris because we're friends. Thank you, Eric, for inviting me to be here. You have a beautiful campus. I've really enjoyed walking around for the last 24 hours, having great meals, and I am extremely flattered to be here. Before I get into my presentation, I do want to say something about Akhil Amar. So Akhil does exactly what Chris says that he does whenever he goes anywhere. You always have constitutions with you. Here it is. You always want to hand them out. The thing is, Akhil Amar wrote a book called The Unwritten Constitution, and I've always wanted to dare him to hand that one out. And I think I could rest on that point. He wrote like a 1,000-page book on the unwritten Constitution. That is not an unimportant point. What is originalism, and is it a good idea? We can't decide if originalism is a good idea until we decide what originalism is. So we have to do that first. And I want to be extraordinarily careful and specific about what kind of definition I am giving to this concept. Here is what I care about. A plaintiff comes to court, any court, and says, the government is doing something to me pursuant to a statute that violates the Constitution. And I want you to give me relief. I want you to tell the governor of Mississippi or the Congress or the president that they can't do to me what this law authorizes them to do. Now, in that context, and only in that context, do I care about what originalism is. And it's in that context I think we should talk about it. Now, in that context, I think Chris's definition is pretty good. We used to talk about original meaning. I'm sorry, original intent. That was the original idea. What did they intend to say? That was Judge Bork's view to some degree and Ed Meese's view. That morphed into Justice Scalia's view that what we're really looking for is the, and I can't say this with a straight face very easily, objective original meaning as the words meant to the people at the time. I'm happy to combine those two things because obviously what they intended to say is quite relevant to what the text means. But I'm willing to say we don't really care. We can take both definitions, add them together, and say what we are trying to do through originalism is say what did the words mean at the time they were written. And I think that's a reasonable definition of what originalism is. Now, when a plaintiff comes to court and says this law violates the First Amendment or that law violates the Privileges or Immunities Clause, which doesn't really happen very often, but anyway, when a plaintiff comes to court and says that law should be struck down, I think a judge has three options about what to do with the original meaning of the text that the plaintiff claims makes the law unconstitutional. And this is a spectrum more than categories, but we can view it as a category. A judge could say, I don't want to hear about that. That was 1787. That was 1868. We're 2018. Don't bring that evidence in my courtroom. I don't care. That's an option. No judge ever says that, except Judge Posner. We'll leave him aside. No lawyers take that position. I don't take that position. No one takes that position. So we can just put that aside. No one says it is completely and totally irrelevant what the words meant at the time. I'm done with that part of it. Now, there are two other options, and these are the two that count. A judge could say, I care a little. Show me what the words meant at the time. I'm interested. I'm going to take that. I'm going to add it to a bunch of other things, obviously precedent, but also tradition and structure and policy and consequences. I'm going to put them all in a pot and stir them together and do the best I can to resolve whether this law should be struck down. That's a very reasonable use of original meaning. It's a different debate, but it is in fact the way Justices Scalia and Thomas operate. It's in fact how all judges operate. I care a little bit, and show me other things, and I'll do the best I can. I call that non-originalism, because there's no such thing as someone who says, I don't care at all. So we take that off the table, and most judges say, I care a little, bring me the evidence. Then there's a third possibility. It's hypothetical, but it could happen. A judge could say, oh, I care a lot. Show me the original meaning. Bring me the historical evidence. Bring me the dictionaries. Bring me what happened in 1868 or 1787. And if I can figure it out, it's going to trump everything else, leaving aside precedent. We're just not going to talk about precedent today. It gets in the way. But even if it's a crazy result, even if modern conditions suggest I don't care. I'm going to go with original meaning. And that's an originalist. I think that's what Scalia said he did. That's what Thomas and Gorsuch say they do. They don't, but they say they do that. That's what many modern scholars say they want to do. They don't, but they say they do. But we could say that's an originalist. Now, that's the form of originalism I want to talk about for the rest of my talk. Someone who thinks it's really important and probably trumps everything else. And I have two things I want to say about that kind of originalism, again, in the context of a plaintiff coming to court and saying, that law violates my rights, and I want you, civil servant, politician, judge, paid with taxpayer dollars, to strike it down. And this may surprise some people. There is a form of originalism, of the kind I'm talking about, that I think is workable, coherent, and preferable, and I wrote an entire book defending it. I think it is completely right to say to the plaintiff in that situation, you're going to lose unless you bring to the court clear and convincing evidence that the law you're challenging violates either the clear text of the Constitution, which never happens. Because unlike Chris's examples, equality and liberty and due process and unreasonable and speech and exercise and establishment are not words that normally have crystal clear meanings in regard to factual circumstances. So the clear text is almost never going to come into play. Or the plaintiff could show everybody agreed about why this amendment or provision was passed, and this law violates it. That also is extremely rare. But it could happen. I think everybody agrees that prior restraints were the real purpose on about the First Amendment. Coming from England and the government shutting down printing presses and wanting permission before they could publish, we all agree prior restraints are the main purpose, original purpose of the First Amendment. The plaintiff is not going to be able to make that case very often. And I'm happy about that because I think judicial review should only be used sparingly. And I get to that not through originalism. I get to that through my best view on how judges should act in our society, how unelected life, what role they should play. And under that view, 98% of constitutional law should be reversed. Now, we can agree or disagree on all the value judgments that go into my thesis about that. But that's a coherent view of originalism, and I think it's more than that. I think it's a grand, wonderful, great view of originalism. Judge Bork had a view very close to that. Raoul Berger, a scholar in the 1970s, had a view very close to that. Lino Graglia has a view very close to that today. I have that view, and almost nobody else does. I'm actually the only originalist in this room today, by the way. But leaving that aside, that's not our world, and that's never going to be our world. I mean, I wish it could be, but I'm not stupid. And judges are not going to give up their power that way. Government officials never give up their power, right, voluntarily. So what does it mean? What's the other form of originalism that we use today? The one that Gorsuch claims to adopt. Randy Barnett. I'm not sure exactly where Chris stands on this, but I think he's in this camp too. What we're going to do is say to the plaintiff, and the defendant, show us your best view on what the original meaning of the text was in 1787, not today, in 1787 or 1868. Give us your best version of that. And if we think that that shows the law is unconstitutional, then we're going to strike it down. And if we're 45% sure, we'll strike it down. Mike Rappaport at San Diego, a very famous originalist, has said if it's 51-49, we're going to strike it down. That form of originalism is terrible, absurd, incoherent, and I'm going to prove that to you in the next 6 minutes, okay? Unfortunately, that's the kind of originalism we have today. And all that does is it smuggles modern values into constitutional interpretation without admitting and being transparent that modern values are coming in. So here are 3 examples, and I'm going to start very heady and serious, and we're all serious, but go down in generality. Abortion. Let's say the Supreme Court decides tomorrow, Casey, Roe, it's a nightmare. We're starting over. We're starting over on abortion. Bring us your briefs, bring us your originalist evidence, let's talk about it in the context of a state law prohibiting abortion. And we ask the question whether, it doesn't matter whether it's the Privileges or Immunities Clause, the Equal Protection Clause, or the Due Process Clause. What did these words mean in 1868 as applied to abortion today? And then we say, now wait a minute, let's all back up. The fetus has rights. The state has rights in the life of the fetus. Women have rights to control their bodies, their reproductive futures, their careers, their lives. And we're going to balance those 2 things by 1868 values. What? Wait a minute. In 1868, the majority view was women couldn't be lawyers. The majority view, the dominant view by far. In 1868, we didn't think it was very important for women to vote. Women were more or less, I'll give you less, Chris, property of their husbands in 1868. So what could it possibly mean to ask what the words meant in 1868, what those values were surrounding those words in a country that's more different than us, than Russia or Afghanistan is today? It doesn't make any sense, and we can't do it. We can't do it. If you think women can't vote, and if you think women can't be separate from their husbands, and if you think women can't be lawyers, tell me now what you think about abortion. What? That's like saying, this is not my quote, but I like it, you don't have a baby brother, but if you did, would you like cheesecake? Right? I mean, how do we begin to answer that question? Another example, affirmative action. University of Texas in 1955 is 100% white, 100%. In 2013, the University of Texas wants to have more racial diversity, so 75% of its students come in through a non-racial top 10 program, and 25% come in otherwise, and they want to use some racial preferences for those 25% to get more diversity in certain pockets of the university, and a white plaintiff says that violates the original meaning of the 14th Amendment. Now, when we say the original meaning of the 14th Amendment's Equal Protection Clause, if original meaning has any use whatsoever, we have to go back and figure out what the meaning was at a time when the views by white people of African Americans were so different than today that we can't possibly translate that. Here's what you'd have to know. Well, the University of Texas, I don't think it was around in 1868, maybe it was, but whenever it was around, the idea that people of color would go there was insanity. Insanity. No one would ever have thought that. So we start right there. Now you say, okay, but times have changed, and we've tried to desegregate. It took a long time, but they're still concerned that African Americans still don't have equal status. How do you explain that to the people in 1868? Now, Chris is going to say that's not the question. It's not what people thought, it's what the words meant. No. No. What the words meant is an abstraction. You can only figure out, if you're trying to figure out what Edgar Allan Poe meant by something, you've got to know something about Edgar Allan Poe. And if you're trying to figure out what the words of the Equal Protection Clause mean in 1868, you have to know what the people at the time thought about a myriad of issues. And when you start doing that and pretend we're going to apply that to today, you're making stuff up. You're just making stuff up. And my last example is President Obama. President Obama sits in the Oval Office or the security place, and he says, there's an American citizen having lunch in Yemen right now. He is a terrible person. He is a terrorist, and we do know he's a terrorist. I'm going to assassinate him with a drone. That's what I'm going to do right now. And he did. He did. No judge, no court, no tribunal ever said that American citizen was a criminal or a terrorist. He was not coming at us on the battlefield with a gun when we can clearly kill him. He is sitting having lunch in Yemen. Now, he was going to do some dastardly things in the future. I think that's pretty clear. But that was the future. Does the President of the United States have the authority to assassinate an American citizen having lunch in Yemen with no judicial due process? By the way, I think that's a very hard question. But we are not going back to the meaning of Article 2 in 1787 to figure that out. How would we possibly do that? You can't blow up New York in 10 minutes in 1787. Let's start right there. The threat levels were very, very, very different. We didn't have unmanned drones that could kill people halfway around the world in 1787. And most importantly, the President of the United States is a completely different, the presidency, is a much different office than it was in 1787. We'd have to say to them things like, we fought a Korean police action without ever declaring war, and thousands of people died, and we've kidnapped dictators from Panama. We can't fill them in on that. So none of that makes any sense. And all that happens. This is why, when you look at history, in 99% of Supreme Court cases, the five conservatives vote one way, and the 4 liberals vote the other. 99% of the time, in important cases. Because all they're doing is pretending that they can go back and take 1868 values, which were pretty horrible, and 1787 values, which were even worse, about slaves, and bring them to today. Now, the way to resurrect all that is, there's only 2 options. One is, I like this one, the Siegel approach, I would like that, and say, for reasons unrelated to history, we don't want judges striking down a lot of laws. That's a mistake. They're unelected, they're life tenured, bad things happen. For liberals, we get backlash. It's all bad. So judges shouldn't do that. And the only way a judge is going to strike down a law is if the plaintiff comes in and shows the original meaning of that text without any doubt forecloses that action. I like that system. It's not going to happen. So the only other possible approach is to say, yeah, we'll look at original meaning for whatever value it has, but in most cases, it's not going to help. We can't possibly figure out what the original meaning of words like equal and liberty and unreasonable and exercise and speech were at a time when women couldn't vote, hold most jobs, when people had slaves, when the executive branch was 100% different. We can't do that. We can look at it a little bit to see what it gives us, and then we're going to be transparent and open and honest and say we're deciding this case the best we can under today's values, today's sensibilities. Can the District of Columbia place a limit on how many guns you can buy during a month? This is a real case. It was 12. And the panel, the D.C. Court of Appeals said no, they can't do that. They can't put a limit 12 on guns. There's no way an historical approach can say yes or no to that, because they didn't know about guns you could hide in your pocket and kill a lot of people with in a very short period of time. So why pretend that matters? It doesn't matter. The Constitution that's litigated, the unwritten Constitution, in the words of Larry Tribe, the invisible Constitution. So we have the invisible Constitution, we have the unwritten Constitution, and we have the Constitution in our pocket. I'll end with this thought. The Constitution in our pocket is something that Chris studies very well and is really great at it. And I'm glad he does that. And that's nice from a historical perspective, maybe a philosophical perspective. But the Constitution in your pocket is absolutely not constitutional law. In this country, constitutional law is what the Supreme Court says it is. If you don't believe me today, read my article in Harvard titled that. But it is what the Supreme Court says it is, which is why Akhil Lamar can write a book, The Unwritten Constitution, why Larry Tribe can write a book, The Invisible Constitution, And believe me, when Justices Scalia and Thomas strike down affirmative action based on what they call a colorblind principle, that colorblind principle is nowhere in the United States Constitution. Read it. Read the one in his pocket. For the rest of your lives, you'll never see it. They made that up. They gleaned it from very general language that doesn't say anything about race and anything about colorblindness. That's the Constitution that matters to us. That's the one I write and talk about. That's the one you as citizens should care about. And for that Constitution, originalism without substantial deference to the decisions of other political actors is absurd. Thank you very much.
Well, this is, I think, sets your position very well. I have two quick questions for each of you, and then we can resume responding. The first, for Chris, in light of how originalism or the 14th Amendment, your history of the 14th Amendment treat women's rights, how do you view the tiers of scrutiny actually protecting women today?
So the tiers of scrutiny, in my book, I criticize them. So Justice Marshall and Justice Stevens and Justice Berger, Chief Justice Berger and Justice Scalia, they all had this view that we should melt down the three tiers of scrutiny into a single level of scrutiny. And actually, the example I talked about before about women, young people, and the freedmen, the Republicans said the fact that young people can't vote, the fact that women can't vote, this is a reason to think that it is not a privilege of citizens of the United States to vote. The Republicans treated discrimination on the basis of race, on the basis of gender, on the basis of age, in the same way. They used them all as a model of each other. But under modern equal protection jurisprudence, they get different levels of scrutiny. So you get strict scrutiny for race, you get intermediate scrutiny for gender, you get only rational basis scrutiny for age. So as a result, I actually agree with Eric that a lot of the basis for the affirmative action cases like Adarand, the fact that you get strict scrutiny, that's rooted in these tiers of scrutiny that just doesn't match the history. So, Craig versus Boren, 1976, it says we've always used intermediate scrutiny. That's historically, it's just obviously false. Nobody believed it in 1976. Nobody believes it today. The casebooks, they invented it in 1976.
So real quickly, how would original meaning treat that today?
Yeah, so the original meaning, the key word is citizen. So citizen means person with same rights as similarly situated fellow citizens. So you have, I think Justice Stevens' concurrence in Craig says, in every equal protection case, I have one question: is this distinction arbitrary or, on the other hand, rational? It's a difficult question. Okay, it's going to depend on all kinds of imponderables, just like it did in 1872 when Carpenter was challenging Myra Bradwell's exclusion from the Illinois bar, and Chief Justice Chase agreed with him. We have some reasoning. You can look at Carpenter's argument. My book defends it in a little more detail, but that's so.
Can I respond to that?
Yeah, sure.
I think you said, correct me if I'm wrong, that the majority view in 1870s was women did not have the right to be lawyers. I think you said that.
Right, most people.
Yeah, okay.
But I think they were wrong. Yeah.
Okay, well, you think they were wrong,
You want me to elaborate? I can.
No, wait. You think they were wrong on the merits. You don't think that's a wrong historical statement. If an historian is just trying to figure out what was the majority view at the time, if that's
The majority view in 1787 was that Maryland had more people than North Carolina.
Numbers are different than values. Don't bring numbers in. Numbers are different than values. I'm asking you a question. A historian says, all I'm interested in finding out is in the year 1872, what was the majority view about whether women had a right to be lawyers? What's the answer?
The majority view, if you had taken a vote, the majority would, as I said, the majority would have said no,
okay,
they can't.
so
The majority would have said that is a non-arbitrary
Okay,
distinction.
good.
They would have been wrong about that.
Okay, no, wait. That being the case, in Siegel's fantasy world of constitutional law, under the federal Constitution, it feels like, we have to amend the Constitution to change that if you think originalism is important. Because we know what history says. History says, what did the words mean in 1868? they meant women didn't have to be lawyers, didn't have a right to be lawyers. That's what we know it meant. Now, the fact that they were wrong, once you take the step, listen, this is crucial. Once you're allowed to say, we know what they meant, but they were wrong, when it comes to values, not numbers, when it comes to equality.
Applications.
When it comes to, we know what they meant, but they were wrong, so we can change it, well, that's just living constitutionalism.
So
That's
you're
all that
you're
is.
not satisfied with just making the tier scrutiny just one arbitrary type of standard and then solving that problem?
I have a lot of, I think Chris is this is a sentence I hate uttering. I think Chris is 100% right about the tiers of scrutiny. But remember,
Scalia was right too. Then.
But remember, I hate that sentence much more. But I do want to say he's right when it comes to the world as it is. Again, in my fantasy world, that's not the question we would ask. In my fantasy world, the question would be, can the plaintiff show, through clear and convincing evidence, this particular restriction violates the text of the Constitution? Now, as far as women and being lawyers, I think there's a very strong argument that if Illinois says women can't be lawyers, that strikes me as violating the words of the United States Constitution, the words equal protection. Now, he's going to deny that, but I think I can make that strong argument. My point is, that's the burden of proof. And that almost never happens in constitutional law cases.
Okay, good. Your turn. So if I think you made a great case that there's so many factors that come in decision making and need to be transparent. But you then went further by saying that constitutional laws are whatever the justices say. So isn't that a scary proposition?
Yes.
Isn't it much better to do the balancing act, whether we come out on different sides of it, but do the balancing act that's happening currently, rather than say whatever the non-justices say? What could you give us for comfort?
Oh, very little. That's not my job. I'm the guy that said the court isn't a court. To answer your question seriously, it's a great question. No one is more pro-choice than I am. I've worked for Planned Parenthood. No one is more anti-gun than I am. No one is more pro-separation of church and state than I am. Having said all that, reasonable people can disagree on all of those questions. I don't know what the best gun policy is, and don't pretend that I do. I have my views on abortion, but someone who thinks it's murder and it should be, that's a reasonable position to have. I think almost total separation of church and state is a great idea. I would take In God We Trust off the coins, but reasonable people can disagree about that. And that's true for almost every common law case. Not true for whether women should be lawyers, but everything else is true. That being the case, the only thing we can ask Supreme Court judges to do, really, is be honest, is be transparent. Justice Stevens and Justice Kennedy, and Justice Souter to some degree. Let's talk about Kennedy. Kennedy was by far the most transparent justice we've had in a long time. His formalism and legalisms were very rare. He used them, but he usually told us exactly what he felt. With the values, gays need dignity. Gays and lesbians deserve dignity. Term limits are bad because the federal Congress needs a uniform identity. He didn't get stuck with tiers of scrutiny and that kind of thing. I agree with Kennedy sometimes. I disagree a lot. But at least he was honest. And that's my answer to you. Insist on honesty.
Thank you. Chris, your 10-minute rebuttal.
Okay. So this is bringing back my memories of high school policy debate. So this is more like a Lincoln Douglas, which was, oh my goodness, they talk so slow.
Who's who?
Yeah. So the first thing the very first thing, or that was the second thing. Eric said was exactly right. We have to, originalism, in order to be an interesting thesis, can't just be that the Constitution matters or the meaning originally expressed in the text matters. It's got to be binding, to be interesting. So saying it matters, which Judge Kavanaugh actually said at one point, originalism is saying the original public meaning matters. Just about everybody thinks that. So that's not even to an interesting thesis yet. So it's got to be binding to get interesting. And Eric is absolutely right about that. He limits himself, this is very interesting, to the case of judicial review, where a judge is saying that a legislative act or an executive act is unconstitutional. The Constitution applies in a bunch of situations other than that. Legislature deciding whether to pass a law. they shouldn't do it if it's unconstitutional. There's lots of situations where it may take a very, very long time for something to come into court. The executive branch has to decide whether to enforce it. The Constitution applies in contexts other than judicial review. So the Constitution is a thing. Eric was saying at different levels, the thing with Green is he thinks the Constitution's a thing. I do. And the level of deference we use in judicial review, that's not going to change the nature of the Constitution. So I think it's quite fascinating to think that following the original meaning of the Constitution rather than kind of updating based on values today, that's a terrible idea if we have this one dial set at 51. But if you dial it up to 98, well, then it's a great idea. How does dialing up the standard of deference with respect to an external document, how's that going to change the nature of the document? I don't think it does at all. Okay. I've written a couple articles explaining my view on deference. Clarity and reasonable doubt in early state constitutional judicial review. It's actually been cited in a court, a concurring justice, but the judges have paid a little bit of attention to it. So I'd say it has to be clear, but not beyond a reasonable doubt, because that's what the early cases say. Another thing is interesting about it, it went by a little quick, but Eric was very clear about this. He said, where do I get my doctrine of deference? I get my doctrine of deference from my moral views about democracy, not from history. I think this renders his view incoherent insofar as he's using a constitution that is historically rooted and a standard of deference that's just sort of something he makes up based on what he thinks is a good idea on democracy. What should we use? What level of deference should we use? We should use the one that is expressed by the term judicial review. And how do we figure out what that meant? We should have the same theory about that we have for the underlying merits. And I got a lot of dirt on my fingernails from that, and you can look at that. John McGinnis, I basically, so McGinnis and Rappaport, they've written a whole bunch of articles together. They actually disagree amongst themselves. So Rappaport says it should be 5149. McGinnis says it should be clearly unconstitutional before a court strikes it down. So that's one, I think, problem with the coherence of the view. One thing that's also interesting, so Eric says there's only two choices. You can either use it sparingly, and you got to show by clear and convincing evidence there's got to be clear text. So it's got to be clearly clear text. Or you can just make stuff up and
I didn't say make stuff up.
Okay, or we can be transparent about, we can be Justice Kennedy. Okay. Well, why are those the only two options? How about just one clear? Okay, clear text. So that's my view. Okay, why do we have to have two clears? Okay, so let's look at these particular cases. Abortion, affirmative action. How do you resolve these? Well, you have to look at whether or not you have sufficient clarity about whether equal citizenship requires a resolution one way or the other. If you're going to say there's some special categorical exemption from an equality requirement for affirmative action, you got to say what that is. Okay, so there's a bunch of different ones proposed. One of them is Caroline Product saying, well, discrimination against discrete and insular minorities is the only thing that counts. If you look at the history of state constitutional equal citizenship provisions, they actually say it prohibits giving special benefits to even a single citizen. Okay, so the Caroline Products isn't going to work. I think it's a difficult question, but there are historical materials available. President Johnson in 1866, he vetoes the Civil Rights Act of 1866. He says this is favoritism for the freedmen. Okay, Lyman Trumbull gives a response to that charge, and I think we should go back to that response to the veto, where he answers the charge. The Republicans faced exactly this issue, and they did not dismiss it out of hand. Okay, so citizenship was the key category, and as Eric says, it doesn't mention race explicitly. Race was an application of that principle. Okay. Yeah, abortion, as I've said, I think the only way to, so to be a privilege of citizens of the United States means to be a privilege either generally enjoyed by most citizens of the United States. If you look at 1873, clearly what a right to abortion was not. Okay, so you can't make an argument based on consensus. You can make an argument for contraception in 1965, so you can get Griswold under a consensus-based approach, but certainly not Roe. But then you have a question of, well, treating men and women differently, treating pregnant women different from other citizens on the basis that there is a purportedly valuable entity inside her, that has to be justified. Can it be justified? Well, there's two arguments that you can embrace. One is Judith Thompson's argument. The other is, so Judith Thompson says women's bodily integrity means you have a right to evict the fetus, even if the fetus is a person. Then you got Michael Tooley's argument that the fetus is not a person because there's not enough going on in the fetus's brain yet. Neither of those arguments is accepted by Roe. Okay, the court says if the fetal person is established, then of course the fetus has a right to life guaranteed by the amendment. So the court is clearly saying that Judith Thompson's argument is out of bounds. And then the court says they don't know the answer to whether the fetus is a person. So the court is not accepting Michael Tooley's argument. I think once you do that, your conclusion is settled. The court doesn't have any basis for saying that it's non-arbitrary to distinguish between people with fetuses inside them and people who don't. Okay, if you put a gun to my head and said, come up with a justification for the result in Roe, it would be by adopting one of those positions as the actual truth of the matter. Either Judith Thompson's argument about bodily integrity or Michael Tooley's argument about fetal personhood not being morally relevant. Okay, given that the court was not willing to do that, they should have deferred as a matter of the basic principle of not making stuff up, not speaking without sufficient clarity, sufficient knowledge of the matter. Okay. President Obama blowing up people in Yemen. Well, actually, the rule in the Constitution is public safety. So when can you take away people's lives without due process of law? In 1862, you see a huge amount of discussion of this. I just read this stuff this summer. And they refer to the habeas provisions. Article 1, Section 9, Clause 2 says that the right of the privilege of habeas corpus, the privilege of the writ of habeas corpus shall not be suspended unless when, in cases of rebellion or invasion, the public safety may require it. And you look at people like Congressman Noel, he gives a very nuanced, I think philosophically careful explanation of how public safety can mean different things in different circumstances. So as technology changes, public safety may require that we drop a drone on somebody. Does that mean we can't go to a judge? I don't think that's necessarily the case at all. Nathan Chapman at the University of Georgia has done a bunch of work about the territorial limits of due process principles. But that, I think, is where we should go. I think the original materials give us plenty of guidance for how to resolve that question. It's not an Article 2 question. It's chiefly a due process question looked at in the context of the habeas suspension rule. The question you got to ask yourself: what is the Constitution? Is it binding? Eric agrees that it's binding. Well, what is it? And if it would be one thing, if we had a certain level of the dial of our judicial review-o-meter, I call it the activismometer. So how much evidence do you need in order to be a judicial activist? Okay, your threshold, if it's 51, you're going to be more of an activist. If it's only 78, if it's up to 78, well, you're less of an activist. The setting on that isn't going to change the reality of what the Constitution is, and that's the question you want to think about what it is. I think it's the meaning originally expressed by the text.
Thank you.
My view on deference is absolutely based on my overall assessment of what judges ought to do. It is 100% consistent with the history of this country. And if you read Dean Traynor of Georgetown, or even McGinnis, or even Chris, you will see that early judges and Alexander Hamilton said it all, actually. We don't have to go to early judges. Hamilton was the foremost person talking about judicial review, and he said judges shouldn't strike down laws unless there's an irreconcilable variance. Irreconcilable. We know what that word means. Irreconcilable variance between a statute and the Constitution. I rest with Alexander Hamilton. One more thing before I get to your list of questions. Whether The Godfather 1 is a better movie than Godfather 2 has no reality. We can have opinions. We can have opinions about the answer to that. Judge Posner's example is, are margaritas better than cosmopolitans? You can't answer that question through logic, historical investigation. It is a question of taste. We can have every statistic Michael Jordan ever compiled and compare it to every statistic Larry Bird ever compiled and watch every game they ever played in high school, college, and the pros. There is no answer to the question whether Michael Jordan is better than Larry Bird. Now, some of us think Jordan clearly is, but there are people who think because of Bird's ability to make the last shot in a game, which was unparalleled, he was better. There's no answer to those questions. There are no answers. It's dumb to say there's an answer to the question, is Godfather 1 better than Godfather 2? It is, I'm not calling you dumb, but it is a dumb question to ask, what does the Second Amendment mean in 1787 as applied to a ban on assault rifles in 2018? There's no answer to that question. There's taste, there's opinions, there's thoughts, but there is no answer. The problem with Scalia and Thomas and Gorsuch and many originalists is that they think there's an answer. Now, what there is are burdens of proof. So appellate judges can't reverse factual findings by district courts unless they're clearly erroneous. Now, some appellate judges do that badly, but most appellate judges, even Judge Posner, defer to the factual findings of district courts on an incredibly consistent basis. Judges and lawyers understand burdens of proof and presumptions. The only way to talk intelligently about constitutional law in the courts, and Supreme Court specifically, is to talk the language of presumptions, deference, burdens of proof. Otherwise, they are in fact making it up. In the sense that my arguments why Godfather 1 is in fact better than Godfather 2, or the other way around, I'm kind of making things up. I mean, I can't make up the facts of those two movies, but I can make all kinds of judgments. De Niro wasn't in the first movie, so Godfather 2 has to be better. That can't be a true or false statement. That's just an opinion. The word liberty in the 14th Amendment gives women the right to terminate their pregnancies. That can't be a true or false statement. That's an opinion. All right, I'm going to run really fast through Chris's questions, not 1 through 7. Is it okay for the Supreme Court to make things up? Unequivocally not. But Chris and I have very different definitions of making things up. The Supreme Court should not distort records and pleadings, and it shouldn't mischaracterize prior cases. But when it's trying to decide whether the Second Amendment prohibits D.C. from prohibiting all handguns, the answer to that is in fact made up, and we accept that as a country. So that's that. Is it the Supreme Court's job to fix the Constitution? I wish it wasn't. I wish it wasn't, but it unequivocally has been. The only reason we have women in this classroom today, mostly, is because of the Supreme Court. I mean, that, over time. And that's true for a lot of other things. So the Supreme Court fixes the Constitution all the time. I agree with McGinnis and Rappaport that it would be a lot better if they didn't, and we did it through the amendment process. But that's not our world. Is the Constitution binding? Yes, yes, yes. Even if ideas are bad, yes, yes, yes. But binding is one thing when we're talking about 2 senators from every state. We know what 2 senators from every state means. That's a binding statement. No establishment of religion, Congressman our bridge to freedom of speech, that's not so easy to say is binding because, for example, the Supreme Court has said obscenity is not speech. Well, that's very controversial. I happen to think obscenity is speech. I could be wrong. What does binding mean in that context? It's an incoherent concept in that idea. Can the Supreme Court get the Constitution wrong? Only every day of their lives. Can a new justice on the court take the oath and get it wrong? Yes, of course. So I want to end with this. I didn't mean to mislead about this. Chris is absolutely right that the Constitution applies in infinite circumstances outside of courts. You would like every congressman to consider the validity of what they're doing, congressperson, to consider the validity of what they're doing when they pass laws. You would like, we both teach at state schools. We are bound by the Constitution. I assume this is a state school. We are bound by the Constitution. We should take into account that when we decide things. It applies all kinds of ways. We don't care. Come on. That's for political scientists. That's for historians. That's for citizens. But when we're talking about constitutional law in this context of original, Bork was talking about judges. Larry Tribe is talking about judges. Gorsuch is talking about judges. That's what we're talking about. And in the world of plaintiffs and lawyers and judges and results and liberties and freedoms and people going to prison, in this country, the Constitution is what the Supreme Court says it is. And I, for one, am totally against that. But that's what it is. Thank you.
Thank you. Let's give up to the judge. This is your chance. I think they've given us a lot to think about, a lot to push back against. So, who wants to take the first question? Anyone? Going once? Yes.
So, question for you. Sorry, what was your
Brother Siegel?
Yes. Yes. I was going to ask, so you disagree with his distinction between application of the Constitution and its essence, essentially? Do you see what I'm saying?
I do. In 1900, a professor at Harvard wrote an article. He's the first one to ever use the phrase living constitution. And this is what he described. He said, the meaning of the Constitution doesn't change, but its application to different fact patterns change, which is the same as Chris's view about sense and reference, which let's just cabin for the moment. I think that is an accurate, descriptive account of what the Supreme Court has done. But it doesn't matter to anybody, anywhere, anytime, anyplace. And this is what I mean by that. So Plessy versus Ferguson says separate but equal is constitutional. We interpret equal to mean separate but equal is fine. Brown says no, that's wrong. Separate but equal can't be equal, right? I don't care, and no lawyer, client, or judge has ever cared, if we characterize that as the meaning of the word equal changed. That's one way of looking at it. Or we could say the meaning of the word changed, stay the same, but its application to different facts, the same facts changed. Same facts, but the application changed. Nothing rides on that. No judge, no lawyer, no client, no real life thing has ever ridden on that distinction. So I think it's accurate, and I think it doesn't matter very much.
I think it does matter. I mean, look at the 14th Amendment. So if you go just with the original expected applications, women basically don't get anything. If you go with sort of updating based on modern values, they get the right to practice law and the right to vote, because, we got to have women voting. If they only get the textually expressed sense as applied to the facts about arbitrariness, they get the right to practice law, but not the right to vote, because it's only the rights of citizens, civil rights. And to say that the sense-reference distinction doesn't matter is essentially saying the difference between practicing law and also practicing law and getting to vote doesn't matter. And that matters, it does matter. So Machen was exactly right in 1900. He fit the best philosophy of language of the time, which Frege had just deployed in German. 1892 is this big article. The dominant view in philosophy of language distinguishes analytic truths from synthetic, which is equivalent, I think, to the sense-reference distinction. This is an important distinction, and it's a matter of living by a principle instead of living by just what we've done in the past.
Wait a minute. I accept Chris's historical statement that in 1868 civil rights meant not voting. I totally accept it. He's a great historian, I get it. Civil rights today means voting, period. No more discussion. We all agree that if you can't vote, wait a minute, if you can't vote today, you cannot exercise your civil rights. That is not debatable. It is not close.
It's debatable.
It's not debatable. If you can't vote, you have no civil rights. I mean, you don't have civil rights.
That's not what they mean.
So,
You want a justice looking at a case, possibly denying voting rights, to say, listen, we've changed our norms, and maybe voting rights weren't included, but today, we were wrong then, and our meaning has changed, and is that enough for you?
my point is, it doesn't matter whether they say the meaning has changed, or they say the meaning has stayed the same, but society has changed so much that what it meant then means something, the application of it has changed. Nothing in real courtrooms rides. I mean, Brown said, all the court cases that said we were wrong then, Lawrence says Bowers was wrong when it was decided. It doesn't matter. It doesn't matter whether it was wrong because it got the meaning wrong or it was wrong because it got the application of a principle to new facts wrong. It doesn't matter. The result's the same for everybody.
Well, you want them to say they were wrong.
I want them to be as honest as they can be.
So what does civil rights mean then? It just means good stuff?
It means a
Voting
lot.
is good, so we get it?
It means a lot of things. It means the right to vote. It means the right to equality.
It means the right to vote? Or
Today it does. Of course it does.
Of course it doesn't.
So I'm really interested in bringing this to the practical application.
I'm trying.
That's what Seagull is doing, but I think there's a lot of value in the work that Chris does. And so I want to know, is there a case in which someone has used the history and gotten it right, where you could say they're being intellectually honest and they're not making it up? I mean, you say that there's a sort of a narrow window of possibilities for cases, the real original cases and non-original cases. I think your view, Chris, maybe is that there's a much broader group of cases where this all applies. But is there an
I have an
example?
example.
I think that makes up a lot.
But
So what's the, give us a gold standard.
I have a good one. I have a good one. But it's a little bit doctrinal. So the question was, can you go into court and argue that the government is doing something unconstitutional without being personally injured? It's a standing question. It's a constitutional law question. Does Article 3 allow a citizen, or anybody, to go into court and say, the government is giving money to private religious schools, that violates the Establishment Clause, what's your injury? I'm angry. I'm mad. I'm not getting money, life, liberty, property. I'm just mad. And in Flass versus Cohen, the court butchered that question. But Justice Harlan, in concurrence, said, and Raoul Berger, a noted historian, agrees with this. Harlan said, you know, Article 3 does not require personal injury. It does not. That may become a surprise to you federal courts people. Harlan said Article 3 does not require personal injury. But I've looked at the relationship between the court, the Congress, and the President, and I think it's a bad idea for us to decide this case, unless Congress tells us to. So I'm going to say, as a matter of equitable discretion, we shouldn't hear this case. But it's not a matter of constitutional law, because the constitutional law is personal injury is not required. It has to be two adverse parties arguing over something real, but you don't have to be injured to do that. So ACLU can do it without being injured. That's a fantastic opinion. It is honest. It goes the wrong way from a liberal perspective. It says you shouldn't be able to sue. Congress can change that if it wants. It is completely honest in every way. That's a great opinion.
Thank you. Very good. Another question? Did you have your hands up? Yeah.
I guess, Professor Siegel, I just wanted you to clarify a little bit more your position on deference, because I'm kind of confused as to where there would be checks and balances for the Supreme Court if they don't have deference. Like, what keeps them from making it up if there's no standard for them to base themselves off of, if that makes sense?
No, I think there needs to be a standard. And let's put it this way. Every Court of Appeals judge in the country is extremely familiar with the standard clearly erroneous. We're not going to overturn district court findings of fact unless they're clearly erroneous. And they don't have much problem with that. Now, there are runaway judges and they're bad, but that's good. Supreme Court judges shouldn't overturn laws unless they're clearly erroneous in the context of inconsistent with the Constitution.
I'd like to follow up on that with your opening statement. Do you have a hierarchy of factors? You mentioned a number of factors that go into decision making. I feel original being the starting point. I'd like to know your hierarchy. Which one do you value more than others, if you have them?
That's a great question. Remember, I would prefer the Supreme Court to get out of the business, pretty much. If the Supreme Court's in the business, I think it's kind of a far eastern perspective on this. There's going to be a lot of different things in the pot. I mean, abortion is so hard, right? I mean, it's not hard for me personally because I have some strong views, but I accept that it's hard for people who, with sincerity, think the fetus is a live human being. So it's really hard. At the end of the day, all a judge is going to do is go, this is the best I can do. And my hierarchy has always been transparency. Admit it's hard, admit there are opposing views, and then say I'm doing the best I can under the circumstances.
So on the stew question, and this is a big problem. It's always been pointed out as a problem for Philip Bobbitt's view. So Philip Bobbitt has this view that we've got these 6 modalities, we've got text, we've got history, we've got precedent, we've got policy. How do you decide which one trumps when they conflict? You just, conscience. Well, if you really take that seriously, conscience is really your constitution, okay? It's impossible for the Constitution to violate your conscience. I think it's just absurd. The Constitution has some really bad provisions that would violate anyone's conscience, certainly before the Civil War. The question for Bobbitt's views, and I think for anybody who's going to say, well, there's a bunch of relevant factors, what do you do when they conflict? What you need is an external thing in virtue of which one answer is right and the other is wrong. A constitutional truth maker.
But there is no external thing. Is Godfather 1 better than Godfather 2? How are we going to measure that?
It tells, like Godfather 2 tells this great story about father and son. It's got De Niro. It's got De Niro.
We are not going to Godfather series.
Yeah, 3 is good, but I mean, not in the same way.
We agree on that.
Okay, you have the floor.
This will be very non-technical because I'm not a law student.
Well,
It seems that your position, what you seem to be saying over and over, is really it doesn't matter what was intended. Or
no, I never said that. I never said that.
Okay, it seems that that is your implication. It doesn't matter what is written, I will say that, it doesn't matter what is written in the Constitution. What matters is what is. You said the judges should.
I'm being descriptive. I'm sorry. I need to interrupt. No, I'm being descriptive in all of that. In 2018 America, that is the way constitutional law is. That's not how I want it to be at all.
So, but my question is that not the whole purpose of the Constitution? Is so that we don't just interpret things like we want to. That we have a set of written rules that we live by.
Right.
No matter how we feel about it.
But tell me what you mean by rule in the context of a provision that says no person shall be denied life, liberty, or property without due process, equal protection of law, or no cruel, unusual punishments, or no unreasonable searches. See, those aren't rules. That's the whole thing. The Senate shall have every state gets 2 senators is a rule. The president can only serve 2 terms is a rule. I think judicial review is a great thing with rules. When it comes to flexible, vague, imprecise standards, then when you give judges the authority over time to flesh those out, what you get is what David Strauss at the University of Chicago has described accurately as a common law constitutional law, and you're ceding a lot of power to unelected life tenure judges, and no one is more against that than I am. There really is no one in this country who has written more against that than I am.
So one thing I did want to point out, so Eric makes this argument about the fuzziness of the boundary. It's a vagueness at the edges, okay? There's a difference between having fuzzy boundaries and having moving boundaries, okay? And I think part of the reason we have this misunderstanding is actually it's Justice Scalia's fault.
I agree with that.
Justice Scalia, he loved 2 things. He loved rules rather than standards, rather than fuzzy standards, and he loved an unchanging Constitution. And a lot of his work, unfortunately, suggests that if it's unchanging, then it's going to be a rule. Well, that implies, that's the same logically equivalent as saying, if it's fuzzy, then it's changing. And I think he and Eric are wrong about that. But it's not completely crazy to say that fuzziness and change go together. I just think if you're careful, I mean, if you pay attention to the philosophical literature on vagueness, that's one way to see that these are just different phenomena.
But I think if it's, unlike Scalia, who made up things all the time like colorblindness, anti-commandeering, sovereign immunity, if it's fuzzy to me, then here's the judge's answer. And I can't tell you how often I've written this. If it's fuzzy, and if I'm not sure, the plaintiff loses. Move on, next case. That's all.
Yeah, I would say clarify it first. But.
This is when, and I'm sorry, did you want to finish your thought?
No, clarify, and then at the end of the day, clarify if you can, at the end of the day, if it's clear, then you uphold it.
So you see that there are way more meeting points between those two than you would think. Obviously, they differ as a golf difference, but they have more meeting points. And I think the linchpin here is we constantly gonna be called to interpret the Constitution in light of changing norms. That's not gonna change. We're always gonna struggle with this. And the job we're doing here is the job we have to continue to do outside. And I hope to see some of the young people in the room in law school. And please join me in giving a hand of